Good morning. Are we ready to bring the jury in?
I have one matter.
Yes.
I'd just like to review. As the board is well aware, we did file a motion in limine to exclude improper opinion evidence, and we have felt at certain points, and I know we've addressed it already before the court. I know there's a motion in limine that the court granted. I wanted to provide the court with some case law, additional case law on that subject matter. The two cases I want to cite to the court are Jackson v. State, found at 107 Southern 3rd, 328, and then also Tumblin, T-U-M-B-L-I-N, found at 29 Southern 3rd, 1093.
Thank you.
And I'll give the court a minute to. I've highlighted the pertinent part. It's on Jackson, it is on page 13 of the opinion, under head notes 3 and 4.
Could we set some time to address this? It's not right in the middle of my cross-examination, because I've just now seen the cases and don't even have the motion in front of me.
Well, the motion had been filed and ordered on. This is just the case law. Let me take a moment.
Case. It's on pages 10 and 11 of that opinion. Okay, I have read both of the cases. What yesterday when we were up at the bench, there was specific objections, and we read back the testimony. So, what is the specific objections? The latter part of the testimony of Detective or Investigator Storino, Mr. O'Mara was asking the investigator specifically to comment in terms of the truth or veracity of what the defendant said or didn't say, and that's improper. And so he is asking investigator, and did elicit from Investigator Storino opinions as to the truth and veracity of what the witness said, which is totally improper. Under the case law and under the motion we filed previously, we would ask the court to strike that and have the jury disregard that.
Okay, do you know specifically which questions and answers that you're objecting to?
I think it was towards the very end, and I can ask the court reporter.
If you'll take a moment to look at that, and then you can allow the court to know.
I'm just sort of in a recess. I'm going to cue up the audio because I want to use it across, so it's going to make some noise. Is that all right?
Yes, sir.
In order to show him that I have to go.
Almost the last question was, and I can just read it well.
Okay, go ahead and read it. We're still off the record.
States, so if we were to take pathological liar off the table as a possibility just for the purpose of this next question, you think he was telling you the truth? Yes.
Okay, response? Now we're back on the record. Let me know when you're there.
Okay, thank you. Hold on. Okay, go ahead, thank you.
I would ask that we given some time not only to review the state's case law, but to come up with my own to respond properly, rather than trying to do it now, since I've just now truly haven't even read those. To the extent that you want at least a partial response right now, this is the chief investigating officer who was interviewing the witness and who himself took on a challenge interview to attempt to identify whether or not this witness was telling the truth or not. Within the context of a challenge interview, within which the whole premise is to determine veracity or truthfulness, I think that since this person took that on, then he can now tell what he believes to be the result of that context interview.
I'll give you a moment to read Supreme Court Florida case Tumlin, T-U-M-B-L-I-N versus State, found at 29 Southern 3rd, 1093, decided in 2010 under Head Notes 9, 10, and 11. I'll quote, allowing one witness to offer a personal view on the credibility of a fellow witness is an invasion of the province of the jury to determine a witness's credibility. It is clearly error for one witness to testify as to the credibility of another witness. Moreover, it is especially harmful for a police witness to give his opinion of a witness's credibility because of the great weight afforded an officer's testimony. Police officers, by virtue of their positions, rightfully bring with their testimony an air of authority and legitimacy. A jury is inclined to give great weight to their opinions. And then another case holding that police officers' comment that witness was credible and positive in her pretrial lineup identification was error requiring a new trial.
I guess my concern, and I'll take a moment to read it, is that in that context, it was a question of affecting the client's right to a fair trial, because in effect what happened in the Tumlin case was the officer vouched for the credibility of an eyewitness who came in and said, I'm certain that that's the defendant. And then the cop came in and said, well, I'm certain that I believe her when she says, I think it's him. That's affecting my client's right to a fair trial. I think it's a much different perspective under the facts of this case. Now, again, I need to read this and also get some case law, but a quick response is, it's a question of whether or not my client's right to a fair trial is being affected. I don't think the same would apply to the state when it's the state's own witness who presented a conflict or an attack argument to my client and he successfully responded. But if I might have a moment to review it.
Your Honor, while that's going on, I do have another matter that I wanted to address with the court.
Okay, well, we can do that.
Controversial is...
Okay, well, just one second. In the Jackson case, which is also Supreme Court of Florida, 107 Southern 3rd, 328, decided November 2012 under Head Notes 3 and 4. Generally, a witness's opinion as to the credibility, guilt, or innocence of the accused is inadmissible. Allowing one witness to offer personal view on the credibility of a fellow witness is an invasion of the province of the jury. Cites to the same cases, but in this case it was the opinion as to the credibility, guilt, or innocence of the accused.
Correct, so not given by a police officer, an adverse witness. That was another witness where it
Well,
was
if you read further down, it cites to Pausch, P-A-U-S-C-H versus State, 596 Southern 2nd, 1216, that holding that admission of officer's statement expressing his disbelief of the defendant's story and accusing her of lying and committing the crime was reversible error.
Again, I don't think that's the facts that we have here.
Well, because they're opposite. He's testifying as to the truth and veracity of your client's statement.
Okay. Just need a moment.
Go right ahead.
Just a quick review. I understand the court's concern. I'm sorry.
Go ahead.
A quick review. I understand the court's concern, but I really would like an opportunity because all of these cases are where that testimony is coming in against the defendant, and it's a question of whether or not that affected the defendant's right to a fair trial. I think that it may well be different, but I just want some time to look to see if this case law where a chief investigating officer who has to determine where the investigation is going, determine whether or not to continue to investigate, determine whether or not what credibility to give to certain witnesses and how to resolve differences between what one witness may have said happened to the other witness. Within the context of that officer's investigation, what he said was, as I was going through, as I was going through the interview, I challenged him, and his response suggested that he was telling me the truth. I just want an opportunity to see if
Well,
there's
but you asked him a specific question. Was he telling you the truth?
I said, do you think he was telling you the truth? Yes.
Well, it's the same difference.
Well, again, I understand the court's concern and the state's objection, but within the context of an investigating officer charged with the responsibility to make exactly those determinations, whether or not he believes him, whether or not he's going to arrest him, whether or not he's going to charge him, whether or not he's going to believe one witness over the other, that is exactly what an investigating officer has to do in the context of his investigation.
And if the question would have been answered, no, I thought he was not telling the truth?
And it would be out there. He could have answered it that way.
Our position is that these cases are right on point. The state is also entitled to a fair trial, and these cases are right on point as to this issue. Mr. O'Mara, on behalf of his client, cannot claim that because the officer said, his belief at that point that he was telling the truth, that should be admissible. As the court noted, the defendant has said he's a liar. In fact, I believe he's guilty because ABC and all that stuff, that's improper. And we had filed a motion in limine that the court heard back in May. The court ruled on it and granted. And I think the rules should apply, the law should apply to the state and to the defense.
Okay, do you have a suggested curative instruction?
I would ask the court, read that, have the court read it or read it back, whichever way, and then ask the jury to disregard that, and that is improper comment by a witness as to the truth or veracity of another witness, in this case, the defendant.
Anything else?
No, Your Honor.
Is Detective Serino here? Oh, you had another matter you wanted to take up?
It pertains to a potential witness for later in the day, that being a Professor Gordon Pleasance. Your Honor may recall the state last week or a little before had filed a motion to perpetuate his testimony due to his being unavailable. That was heard, objected to, and granted. We scheduled the deposition to perpetuate for the last night that he would be in town, which was, I think the motion was granted on a Monday morning, and he was set to depart Wednesday morning, so we set the deposition and noticed it for Tuesday night. Everybody showed up except the defense, and I communicated with counsel for defendant on that night, and basically I think it was just a matter of people forgot about it in all the rest of things that was going on, and I understood that, but my problem was, and I explained this to them, that the witness wasn't available to reschedule because he was having to be at the airport in the morning and fly out and was going to be essentially unavailable. So I proceeded to at least preserve the direct testimony on videotape and a transcript, both of which have been provided to counsel. The witness indicated that there would be sporadic availability perhaps for video conference type testimony. He is traveling through the New Mexico desert, I believe, on kind of a hike, and is occasionally reachable by cell phone, or if we leave a message when he gets to a next destination, sometimes he can find enough service to call. Yesterday I managed to reach him via that method, and Mr. West informed me last night that they were not going to be stipulating or agreeing that the perpetuated testimony could or should be admitted, and therefore they wanted the witness, if he was going to testify, to have to do so, I guess, by video link or some other such. He is not available to do that today for sure because he is in transit, he said, across a couple different states and given the environment. He may, once he arrives tonight, be able to locate a place to be available tomorrow morning, even though he's a couple time zones away. But he can't guarantee me that. He just believes that that would be likely. So I wanted to, number one, bring that to the court's attention. Number two, hear how the defense would propose that we handle that situation or issue if there's an objection to what's potentially playing that videotape, and get that out of the way now before we run into it this afternoon when we want to call a witness.
Okay. Response?
I'm not quite sure what the proposal is. I think it's to play the video of Mr. Pleasant's direct testimony and then not afford the defense an opportunity for cross-examination. I don't know if that's it. That, of course, is completely unacceptable. If Mr. Manti seeks to offer the witness's testimony through Skype, then he should offer the direct, and then we can cross as appropriate. We also need an opportunity, though, to speak with Mr. Pleasance prior to him taking the stand by whatever method that he does. The motion to perpetuate, as the court's aware, was a last-minute motion during the course of the trial when the state realized Mr. Pleasance wasn't available. We don't fault them for the effort that they made. We didn't become aware of the significance, frankly, if any, of this witness's testimony until, as well, sometime after the trial started, when we began to realize why he was being offered in connection with Mr. Zimmerman's coursework. I think Mr. Pleasance may have taught an online course at the Seminole State College. In any event, the issue last Tuesday was a scheduling complication. I don't dispute that the deposition was set sometime after court on Tuesday, and that at some point may have known that. There were no reminders or any conversation during the day, and then at the end of the day, when Mr. Manti had set up the video deposition with Mr. Pleasance here and contacted me by phone to say, "Where are you?" At that point, we had already left the courthouse, but more importantly, Mr. Zimmerman had already been escorted off the property. A motion to perpetuate testimony either requires the accused's presence or a specific waiver, and we were unable to accomplish either of those at that moment. I apologize to Mr. Manti, and here we are today. As the court's aware, we've been working full days and then some, and of course there's lots of work to do at night and on the weekends. With this witness's unavailability, I think we should target when he is available, give us a chance to talk with him, and schedule his testimony by Skype if he's otherwise allowed to testify. We have no objection to that. We have no objection that the court place him under oath as opposed to him being in the presence of a notary, wherever it is where he testifies. And we have no objection if at some point when he testifies it's out of order.
Okay, response?
I guess my response to that is twofold. If we're discussing waiver, the state's position is, we had the argument on Monday. The court was pretty clear in its ruling. I think we were all pretty clear on the reason that we had to do it was because the witness was leaving before we would actually have the opportunity to start trial and present his testimony, and that's the reason it was set when it was. So from the state's position, number one, for whatever reason the defendant and his counsel didn't show up, we think that should constitute a waiver of the right to presence. Simply not coming isn't really a reason to bar the direct testimony. My proposal, my counter-proposal is that we play the direct, and there was one exhibit that he identifies during the direct and that I intended to introduce. Play the testimony of the direct, introduce it, and if counsel wishes to cross, then hopefully he would be available tomorrow, but I can't, obviously I said, I can't guarantee that given the locations and places, and that's the reason we moved to perpetuate in the first place. And if they want to cross at that time, that's fine. I'm not attempting to deprive them of the opportunity to completely to cross.
Well, there's a lot of different scenarios that could play out here, and if you could find out sometime today what his availability would be tomorrow, let me table this argument till this afternoon.
Yes, Your Honor. Thank you.
Okay, thank you. Is there anything else? Let's get Officer Serino in here, please. And Shelley, can you queue up to that last question and answer? Are we ready to bring the jury in?
Yes, Your Honor. Your Honor, thank you.
Let's bring them in.
Just that one question.
That one question and answer, yes. I think it was like taking the hypothetical out of it. Please be seated. Shelley. This one. Okay. Good morning, ladies and gentlemen, and welcome back. During the overnight recess, did any of you have any discussions with each other or with anybody else about the case? No hands are being raised. Please raise your hand if your answer is yes to any of these questions. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do any independent research about the case? People, places, things, terminology. No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you. I'm going to have the court reporter read back a question and answer from yesterday afternoon and give you an instruction on that. Shelley, you may do so.
Question was, so if we were to take pathological liar off the table as a possibility, just for the purpose of this next question, you think he was telling the truth? Answer, yes.
Okay, ladies and gentlemen, my instruction to you is that that is an improper comment by a witness as to the truth and veracity of another witness, and you are to disregard the question and the answer. Thank you very much. Mr. O'Mara, you may proceed.
Morning, officer. How are you?
Good morning, sir. Fine, thank you.
When we were talking yesterday before break, we were talking about we agreed to use the term challenge interview, correct?
Yes, sir.
And we were talking about the context of that challenge interview, right?
Yes, sir.
Some of what you challenged him with in the context of that interview. I want to back up a little bit. I mentioned yesterday as an example that one technique that law enforcement officers are trained to use is what I call a command voice, and of course you're familiar with that, right?
Yes, sir.
That's when you basically have to take control of a situation and you say it in a stern voice, almost a yelling voice, because what you want to do is let everyone know you're the person in charge, correct?
Yes, sir.
In that context, you're not actually yelling at the person like you're angry with them, are you?
No.
It's a technique to gain control of a situation, correct?
Yes, sir.
Similar in the challenge interview, it's not as though in this context you're actually angry with Mr. Zimmerman, correct?
No, anger's not a part of it. No.
Right. It's just a technique or a tactic that you use to try and undermine his confidence in his own story so that you can see if he breaks, correct?
Yes, sir.
And that's the purpose of it, correct?
Yes.
Okay. So that when you challenge him, in an example, you said to him, you sound kind of frustrated on the phone conversation, because everyone's going to hear these things, you know. What was your purpose in that?
On which phone conversation? On which phone conversation?
I presume, having read the entirety of your interview, that you're talking about how he sounded on the non-emergency call.
Okay.
And was that in an attempt to sort of, again, undermine his confidence in himself so that you might get some movement in his story?
Not necessarily. I mean, it could have been.
Okay.
I'm not quite sure my comment might have been or what tone I might have used.
Okay. Would you then defer for the jury's consideration to the way you present to yourself in the challenge interview rather than just me going over or repeating it in sort of bare words?
Yes, sir. Yeah.
But you agree that your purpose was to challenge Mr. Zimmerman?
It could have been, yes, sir.
And to try and undermine his confidence in himself such that he might tell you more or change his story in some way which would then give you an opening, correct?
I would classify it more trying to extract truth if he's hiding it, yes, sir.
Sure.
If
And did you extract any truth or anything, any change in his story through this technique?
No, sir, I did not.
He was, in fact, consistent throughout, correct?
Yes, he was.
And he was also consistent with both all of his prior statements, correct?
To my knowledge, yes.
Okay. As the chief investigating officer, you had availability of those prior statements, correct?
Yes.
And there were some changes. I think you said yesterday there were certainly some expansions and even some minor inconsistencies, right?
Yeah, there was some variations of accounts.
But nothing that you considered significant?
Nothing major, no.
Nothing that evidenced to you that he was lying to you?
Objection, Your Honor. It's an improper argument.
Sustained.
Any inconsistencies that you consider to be significant?
None which I can challenge him with, so I would say no.
Okay. With some help, hopefully this will work, I'm going to play with you a portion of the tape that you heard yesterday. I understand that I'm going to play it. If you can't hear it, I'll play it a second time. I believe this is a part to focus you on the investigation where you are playing for Mr. Zimmerman the 911 call, which has the screams in the background, to put it in context. And I'm going to try and get the volume correct, Your Honor, so I may need a couple of tries. Oh, sorry. It is 182. It is the...
Okay, and is it a male or female?
It is a male.
And you don't know why?
I don't know why I'm yelling help, but I don't...
Did you hear, Mr. Zimmerman?
I'd have to hear it again.
Sure. I'm going to keep it low, Your Honor, until we get back to that point.
But now we're here, work with you here, okay? Now, let's work that up in your mind, okay? And if there's anything that needs to be changed...
Your Honor, I'd ask that it be played at the
sorry.
same level so that the jury can establish the
I
context.
think he's just trying to
I'll
figure
do
that
that,
out.
Your
I
Honor.
can't do this anymore, yeah? Okay, this one.
911, you need police, fire, medical?
Hear that voice in the background?
Both, I'm not sure, there's just on screen. 911, you need police, fire, medical?
Maybe both, I'm not sure. That's you.
On screen, that's...
In the transcript, and I think it was pointed out on 2 occasions by Mr. DeLoreonda yesterday that there was a suggestion that Mrs. Zimmerman said, doesn't even sound like me. Do you remember that?
Yes, sir.
Now, is it your opinion? Well, your opinion, did you interpret that Mrs. Zimmerman was denying that it was him, or just that it simply didn't sound like him?
Your Honor, I'm going to object as to having this witness testify about what the defendant was thinking based on what he said.
Okay, sustained.
Did that change the direction of your interrogation of him, that statement that he said, doesn't even sound like me, did that change the direction of your interrogation of him at all?
No, it did not.
Did that cause you any concern whatsoever?
No, it did not.
If I might just have a moment, Your Honor. I want to make sure that I get the right portion of the tape. And I think I might need to just play it a moment more. So I'm going to do that now, and it may be on that portion.
And what's the address that they're near? 1211 Twin Trees Lane. Twin Trees Lane? Is this in the Twin Lake Town, in Sanford?
Yes.
Okay. And is it a male or female?
It is a male.
And you don't know why?
I don't know why I'm yelling help, but I don't know. Send someone quick, please.
Okay. Does he look hurt?
Did you hear it then, in the background?
What he said?
Yeah. Nonetheless, you heard it that night, correct?
Yes.
And you heard his words being, "Does it even sound like me?"
Yes.
That didn't change what you did as far as the investigation?
No, I did not.
Similarly, in the challenge interrogation, you even told him that you were moving from the interrogation room to another area out by your desk as well, correct?
Yes, sir.
That was both to listen to the tape, correct? But to also change the setting for him?
No, it's exclusively because of the facility. I didn't have I didn't have a computer inside the interrogation room.
Now, you said in response to a question from Mr. De Leon yesterday that you perceived Mr. Zimmerman's injuries to be minor, correct?
Yes, sir.
And that was as you looked at him that night after midnight, correct?
Yes, sir.
And we showed you the picture of his injuries before he was cleaned up, correct?
Yes, sir.
Did he need to have any injuries at all for you to look into the investigation concerning both the crime and any possible defenses?
No, sir.
That's not an element, is it?
No. As far as him having injuries, no.
And you saw him on the 27th after midnight, correct?
Yes, sir.
And then he went to work the next day and then saw you for the 27th in the afternoon for the recreation or the recreation video, correct?
Yes, sir.
And then he came back to talk with you again voluntarily on the 29th, correct?
That's correct.
And did you talk to him after that?
Yes, we had conversations.
And that was over the phone?
Yes, sir.
Did you talk to him again in person?
Not that I can recall.
When you spoke to him on the phone, that was in order to, again, sort of forward your investigation of both the crime and any defenses to it, correct?
I believe he contacted me, but yes, the ultimate goal would have been to forward the investigation.
And in all of his communications with you, even after the 29th, he was cooperative?
Yes, he was.
Answered whatever questions you had for him?
Yes, he did.
Presented himself to do whatever it is that you wanted him to do?
Yes, he did.
You have done even more than just take the interviews of my client as part of your investigation in this case, correct?
Yes, sir. From other aspects of the investigation, yes.
Met with other witnesses?
Yes.
You met with Tracy Barton, correct?
Yes, I did.
At your office?
Yes, there at his residence also, or at the residence in Twin Retreat Green, yes.
Why did you meet with him at your office?
No objection, it's beyond the scope of direct and calls for hearsay too.
Well, actually,
Okay, let me take it one at a time. It was not covered in direct. It's not hearsay, the question and the answer that it would elicit. I have to sustain on wasn't covered in...
may I respond?
Yes, you may.
I would just allow a little bit of leeway for this, the chief investigating officer in the case, to ask him what else that he has done in doing exactly his duties.
Well, you could do that in your case.
So I will call him as my witness.
If you choose to do so.
Then I will do that. Thank you, Your Honor. And I need to get this back to the clerk. If I can just have a minute. Are you going to use it?
Not right now.
Redirect it.
I actually do know how to use a laptop on occasion. Thank you very much.
Good morning, sir.
Good morning, sir.
I'm not going to ask you to the opinion of anybody or to guilt or innocence. You understand that's improper, and I can't ask you that.
Yes, sir.
My question is,
Let me object, Your Honor, as to that non-question of this witness. Nothing but a comment on your previous ruling, which is inappropriate.
Sustained.
my question is, Mr. O'Mara, on behalf of the defense counsel, asked you some questions about anger and disdain. Do you remember that, about ill will, hatred, all that stuff?
Yes,
Do
sir.
you remember him asking you a series of questions regarding that?
To somewhat, yes, sir.
Okay. Specifically asked you about your interview with the defendant, that you had reviewed it, and also Investigator Singleton's interview, and whether you found any evidence of hatred, spite, anger, disdain, ill will. You recall a series of questions regarding that?
Somewhat, yes.
Okay. Want to play something for you, sir? If I can figure out how to do this.
Just use this drop down.
Okay. Got those them all there? Oh, okay. I'll first play from you from the non-emergency call that defendant made.
Okay. These assholes, they always get away.
Is that something you would use in reference to somebody that you're going to invite over for dinner? Would you call them these assholes?
No, sir, I would not.
Does that seem like to you like a friendly comment about somebody else?
No, sir, it's not.
Okay, how do I do it again now? I gotta hit this.
Yeah, he goes straight in, don't turn and make a left. Shit, he's running. He's running? Which way is he running? Down towards the entrance of the needle. Okay, which entrance is that he's heading towards? The back entrance.
Did you hear that last comment the defendant stated, and pardon my language, these fucking punks?
Yes, sir.
Okay. Is the word, pardon my language again, fucking punks, something that you would refer to, something good about people when you reference them?
No, sir, it's not.
Are you saying, or you did testify when you were cross-examined, that those two, these assholes always get away, and pardon my language again, these fucking punks, that he said that because he wanted to interact and meet and invite Trayvon Martin for dinner that night?
Excuse me, Your Honor. That would be speculation.
Sustained.
Are you saying that those words were uttered by the defendant in reference to wanting to meet the victim?
Excuse me, Your Honor. That would be speculation.
Okay.
I'll be glad to rephrase it.
Sustained.
Does that not indicate ill will, hatred, and spite against somebody else, sir?
No, it does not.
In your opinion, calling somebody, reference them as, pardon my language, fucking punks?
That is ill will and spite.
It
Correct.
is?
Yes.
Okay.
Are you following him? Yeah. Okay, we don't need you to do that. Okay. All right, sir, what is your name?
Sir, you were asked by Mr. O'Mara on behalf of the defendant in terms of whether there was evidence that he had followed him or not. Do you recall being asked that?
Yes, sir.
And do you recall you, in fact, to use Mr. O'Mara's words, challenged the defendant regarding that? Do you
Yes,
recall
sir.
that?
Yes.
About whether the defendant was following him or not? Do you
Yes, I
recall
did.
that? Did you hear the word there by the non-emergency operator about whether he was following him or not?
Yes.
And did the operator not tell the defendant not to do that?
In so many words, yes.
Okay. In your interviews and review of Investigator Singleton's interviews,
Would you mind taking that off the screen?
sure. Sorry. In your interview and review of Singleton's interviews, Did the defendant, in your interviews of him too, did he ever say he was excited? You want me to rephrase it? I'll be glad to rephrase it. I apologize. In your interview, and also your review of Investigator Singleton's interview of the defendant, which you've had an opportunity to do, correct?
Yes, sir.
Mr. Romero asked you about those. And did the defendant ever indicate that he was happy that there were burglaries being committed at Retreat at Twin Lakes?
No, he did not.
Did he ever say he was excited that his neighborhood was getting burglarized?
No, he did not.
In fact, didn't he say this, sir?
950. This is the correct one? Okay. So you live at 1950 Retreat View Circle. Okay. I'm just gonna keep quiet, and you tell me the story. You tell me what happened tonight, okay? Just tonight? Yeah, or whatever led up to this. Anything you want to tell me about what happened and why it ended up, what it ended up to where this boy got shot. Okay.
The neighborhood has had a lot of crimes. My wife saw our neighbors get broken into and she got scared.
Can you talk about the residents or vehicles?
The residents.
Okay.
While it was occupied. So I decided to start a neighborhood watch program in my neighborhood.
Okay, what is the name of the neighborhood?
Retreat at Twin Lakes.
Now, Investigator Singleton asked the defendant what led up to this in terms of the shooting, correct?
Yes.
And that's how you replied, correct?
Yes, it is.
Neighborhood watch, okay.
With Wendy Dorval, Sergeant Hertz, Officer Buchanan, and I'm the coordinator. And there's been a few times where I've seen a suspicious person in the neighborhood. We call the police, the non-emergency line, and these guys always get away.
Okay. What made them suspicious?
You recall hearing that in terms of Investigator Singleton asking him, the defendant, about what was going on, and he's stating, as he stated there, that they always get away? You
Yes,
recall
sir.
that?
Yes.
Didn't he say that to the non-emergency operator also? But he used more colorful language, pardon my language. He used, these assholes always get away, correct?
Correct.
And those words were uttered within minutes of the actual shooting, weren't they?
Yes, they were.
I had called before, and the police had come out, but these guys know the neighborhood very well, and they would cut in between buildings and loot.
You're saying these guys, who are these guys?
The people committing the burglaries.
So you've seen more than one person, like, looking suspicious and doing these burglaries?
Yes, ma'am.
Okay.
Now, Investigator Singleton had him clarify when the defendant in that interview on the 26th stated these guys, he had him clarify or describe what he meant, correct?
Yes, sir.
And defendant said the people committing these burglaries, correct?
Yes, sir.
And then to the non-emergency operator earlier that evening, when he spotted Trayvon Martin, he made reference to, using more colorful language, pardon my language, these fucking punks, correct?
Correct, sir.
So when Mr. O'Mara asked you about profiling, isn't it accurate that he was profiling Trayvon Martin as a criminal? He assumed that he was a criminal that night?
The object, Your Honor, that call for speculation.
Sustained as to speculation.
Do you recall Mr. O'Mara asking you about whether he was profiling the defendant, Trayvon Martin?
Yes.
Okay. If somebody were to believe that another person is a criminal, could that be a form of profiling?
The object, Your Honor, that would be either speculation or irrelevant.
Overruled.
If I were to believe that you're a criminal, and I followed you and did something, wouldn't that be profiling you?
Then I would object based upon improper opinion testimony unless we're opening that door.
He can testify if he knows in his experience as a law enforcement officer.
As long as we're going to his opinions, fine.
Let me make sure it's clear. If I were to believe that somebody was committing a crime, could that not be profiling that person,
Object,
believing?
Your Honor, leading.
Overruled is deleting.
Do you understand my question, sir?
Yes, I do. It could be construed as such, yes. Construed as such, yes.
Your review of the evidence there, was there any indication that Trayvon Benjamin Martin, the young man, I think 20 days past, had just turned 17, was committing a crime that evening, sir?
No, sir.
Was there any evidence that that young man was armed?
No, sir.
You were asked by Mr. O'Mara several times, and I think he made reference to your last interview being a challenged interview, I think. I don't know if you completely agreed with him on that or just agreed to use his terminology for that. Did you agree that that was a challenging interview?
I wouldn't quite classify it as that. However, it could be viewed as a challenging interview based on his view of it.
Okay, his being Mr. O'Mara's?
Yes.
Okay. Let's assume for purposes, let's call it a challenge interview, but you know what I'm referencing to?
Exactly.
Your last interview with the defendant on February 29th.
Yes, sir.
Okay. And Mr. O'Mara asked you whether there was inconsistencies or not.
Yes, sir.
Okay. And I want to play certain parts of you where I believe you at least questioned him about whether he had said something inaccurate before or said something different. Do you recall that?
Yes, sir.
And I want to ask you about these, if I could.
Okay, just let me know if he does anything else. Yeah, we got him on the line. Just let me know if this guy does anything else. Okay. This asshole would always get away.
That statement. These assholes. What's behind that?
People that victimize me.
Can't you just tell us from there that a week earlier?
Do you recall you playing that recording for the defendant and asking him about that? Now, that somebody may refer that to a challenge, but do you recall questioning him about that?
Yes, sir. I pointed it out to him.
Okay. And he made reference to, when he made reference to, pardon my language, these assholes as people who commit crimes, correct?
Yes, sir.
Told me not to follow him, and I wasn't following him. I was just going in the same direction he was.
That's following. Okay. So you basically wrote it off. I mean,
Right, and I was on the other side.
Now, you were questioning him, pointing out an inconsistency, weren't you not, that he was, the defendant was claiming he was not following him, and you're telling him, that's following him, correct? You recall saying that?
Yes, sir.
Is also this. So she's running, and I'm getting out of my car in an instant to make sure I don't lose sight of this guy. That's what it sounds like. Are you following him? Because that's what it sounds like you're doing. That's why he asked you the question. It sounded to the dispatcher likely that you were running, and that's why he asked you that question. Are you following him? And your answer is yes. Okay? But then you get to the other side, and you're concerned about walking past this guy when you've already been chasing him, essentially. And he's telling you to go back to your car, and now you want to pretend, or not pretend, you want us to believe that you're concerned about having a flashlight to move back where you just ran?
you're
Kind
looking
of
for
protect him. You know what I'm saying?
Okay, it sounds like you're looking for
Do you recall you and Investigator Singleton questioning him about that?
Yes, sir.
About there possibly being an inconsistency based on what he's saying and what the evidence showed?
An inconsistency as far as his acts and his words,
Yes, sir.
to clarify.
Right. And by the way, while we're at this point, Mr. O'Mara asked you about videotaping. You recall that you had questioned the defendant about videotaping, and you showed him the victim's camera that was at the scene near where his body was. You recall that?
Yes, sir.
And you stated, I believe, in direct and in cross-examination that you were bluffing him. You were telling him that the victim had potentially videotaped the whole thing?
At that point, yes, it was a bluff.
Is that correct?
Yes, sir.
And you knew that not to be true, correct?
At that point, yes.
Okay, all right. And my point is, and the defendant made a comment like, oh, I hope to God it was videotaped. You recall that?
Yes, sir, I do.
Okay. Now, Mr. O'Mara asked you about stores and other places that have videotapes out there.
Yes.
Correct? Mm-hmm. Now, the defendant, I believe you've already testified, was head of the neighborhood watch, correct?
Yes, sir.
And had lived in that neighborhood for a while, correct?
Yes, sir.
Okay. So he would have been aware whether there was videotaping or not in any of those buildings, correct?
I would assume so, yes.
Okay. And I know you weren't there when it happened, but you would agree that the interaction between the defendant and the victim in this case, the defendant was aware of whether the victim, before he got shot, took out the video and videotaped the defendant, correct?
Judge,
would know that.
I would object, that would be speculation.
Sustained.
Was there any evidence that the victim, before he got shot, said, hold on, before you shoot me, let me take out my camera and take a picture of you as you're shooting me?
No, there was none.
Was there any evidence that the victim, as the defendant was following him, said, hold on, I'm going to take a photograph of you so there'll be a record before you shoot me that you're following me?
I object, Your Honor, that was asked and answered.
Overruled.
Was there any evidence that the victim, as the defendant was following him, said, hold on, stop right there, let me take a photograph of you or let me videotape you before you shoot me or before you're following me and then shoot me?
No, sir, no.
And so when Mr. O'Mara asked you about whether the defendant knew that or not, he would have known that, correct?
I would assume so, yes, sir.
So he basically knew you were bluffing, is what I'm getting at.
Objection,
Based
Your
on-
Honor. That would be speculation.
Sustained.
I'll be glad. Let me play another recording for you if I could, sir.
That you're concerned about having a flashlight to move back where you just ran?
You're looking
Trying to catch up
for,
to him. You know what I'm saying?
okay, it sounds like you're looking for.
You brought a flashlight with you.
Yes, ma'am.
You wanted to be able to see him.
You want to catch him? You want to catch a bad
It
guy?
doesn't, that's...
Fucking punk can't get away. Listen, we're outside the interrogation room, okay? We are in a whole different area right here, okay? This is where, you know what I mean?
You were questioning him about what he had said, about the evidence, correct?
Yes, sir.
Is that what you were doing there?
Yes, sir.
Can you recall? At what point this interrogation happened? Prior to you shooting him, he was on you, correct? Okay. And you were able to reach into your holster? He shot her at point blank range. He was on top of you, right? Yes, sir. And wherever that young, nobody came out to help you, and I can't pinpoint where you were smothered. That's the problem I'm having. And nobody's saying they saw him smothering you. People are saying they saw you on top of you, but they didn't see about the smothering part. So,
When we're listening to the screaming, it doesn't sound like it's a hesitation for screaming. It sounds like it's continuous. When someone who knows, it's going to stop. But we don't hear it stop.
we don't hear.
You recall you and Investigator Singleton challenged, to use Mr. O'Mara's words, challenging him about whether he was being smothered or not?
Yes, sir.
Okay. Can we play? Finally, a moment, Your Honor. Do you recall watching on direct and then on cross-examination, I believe it was on direct, I apologize, it was, being asked questions about the videotaping, the reenactment?
Yes, sir.
That occurred on the 27th, you recall that, between the defendant, when you took him back out to the scene? Do you recall that?
Yes, sir.
Okay. You were present for that, is that correct?
Yes, I was.
Okay. And do you recall that at some point the defendant walking, as he's walking, and he's walking the route where he claimed he went? Do you recall that?
Yes, sir.
Okay. And do you recall him at some point saying that he went to look for an address and there were no addresses to the left there because those were the back of the buildings? Do you recall that?
Yes, sir.
Okay. And I'm going to try to key to this point specifically, but do you recall?
I think I told the operator that.
I'm sorry.
And he said, are you following? For a street sign. Right. So I got out of my car and I started walking. Go ahead. I was still on the phone with non-emergency and I started walking. Okay. Down this way. And because I didn't see a street sign here, but I knew if I went straight through that that's Retreat View Circle, and I could give him an address, because he said, just give me the address of the house you're in front of. And there's no address, because these are the back of the houses. So,
Do you recall that testimony, sir?
Yes, sir, I do.
Sir, do you recall?
I don't know an address. And again, they asked me where he went, what direction he went, and I said, I don't know. And then I thought to get out and look for a street.
Right there on that corner lived Miss Lauer. You recall that?
Yes, sir.
When you get back in the photographs. I want to show you a photograph of the front of Miss Lauer's residence. Isn't there a numerical address right there in the front of her house?
Yes, there is.
Isn't her address 1211? Sir?
Yes, sir.
Okay, how do I get back there? So, as the defendant, no, you stay right there on that photograph. So, the defendant in that reenactment, when he's pointing at all the back of these houses, where he's claiming he doesn't have an address, there's an address right there staring at him. Isn't that true, sir?
Yes, there is.
That would be leading. This is still redirect.
I'll be glad to rephrase the question. When a defendant turns and points on video to this side where he's saying there's no address because it's the back of the house, right to the right, what is there? Is there a house there with an address?
Yes, there is.
Can we go to the aerial exhibit? For the record, that was State's Exhibit 33. Just number 1. And let me show you State's Exhibit number 1. And I'm going to put a close-up of part of that. For the record, State's Exhibit number 1, a scenario photograph of the retreat of Twin Lakes, correct?
Yes, sir.
And as you pointed out when you used Mr. Romero's words, challenging the defendant in that interview, you pointed out there was only 3 actual streets in the whole neighborhood, correct?
Yes, sir.
And this street the defendant claims he did not know is Twin Tree Lane, which is the main entrance that you come in and out of that retreat of Twin Lakes. And right here, I'm pointing to is Miss Lauer's address, correct?
Yes, sir.
So the defendant, when in that interview, claims he did not know this street and didn't happen to see the address here, but specifically did not know this street, correct?
Yes, correct.
Okay. Thank you, Your Honor. recall also on cross-examination, defense counsel asking you about inconsistencies or consistencies, correct?
Correct.
Do you recall the defendant in the interview that he gave you and Investigator Singleton stating that after he had shot Trayvon Martin said, oh, or something, put his hands up, correct? Do you recall that?
Yes, sir.
And do you recall that he then stated that Trayvon Martin somehow fell on the ground face first? Do you recall that?
Yes, sir.
And do you recall the defendant stating that he put his arms out, correct? Do you
Correct.
recall him saying that?
Yes, sir.
Now, sir, if I may approach the clerk. Do you recall, sir, that one of the first, in fact, the first person that actually came out before the officer was a person named Manalo, Joe Manalo?
Yes, sir. Jonathan.
I'm sorry. Jonathan Manalo, I apologize. And may I approach the witness, Your Honor? Showing you State's Exhibit 77. Do you recall that he took some photographs out there?
Yes, I remember those, yes.
And one of them was State's Exhibit 77?
Yes, sir.
And may I publish that to the jury, Your Honor?
Yes, you may.
And you recall in that photograph the victim's hands being underneath his body?
Yes, sir. Yes, sir.
Could someone say that that was inconsistent with the defendant's statements that his hands were straight out, that he had put his hands out?
That positioning, yes.
I'm sorry.
That positioning as seen there, yes, it is.
Talk to this man.
In that interview that you conducted, or Investigator Singleton conducted, the defendant didn't say, I put his hands out, and then after I put his hands out, I put him back in, did he?
No, he did not.
I think in cross-examination, you were asked something about exaggeration. Do you recall being asked about that?
Yes, sir.
And do you recall, I think either you uttered it or Mr. O'Mara uttered it on behalf of the defendant, exaggeration. Do you recall what that was about?
Pertaining to the defendant's statements,
You felt he was exaggerating certain parts of it?
among other things.
Did you feel, I can't lead you, so
Okay.
did you feel in terms of exaggeration, what did you mean when you said that he was exaggerating parts of his interview?
How I felt, okay, based on,
Okay, no, what I'm getting is inconsistent. I want to give you, I don't want to,
okay.
you were asked specifically about exaggeration. Did you feel he had exaggerated the manner in which he was hit?
Yes, sir. Yes, sir.
Regarding your interview with the defendant on February 29th, was your investigation still ongoing?
Yes, it was.
Okay. Had you, at that point, and even further, had you gotten any results back from FDLE regarding the analysis done of the clothing or anything else regarding that, sir?
No, sir, I had not.
Had you gotten the medical examiner's report or examination in terms of final findings regarding that?
No, sir, I had not.
Had you gotten any results regarding possible DNA?
No, sir.
Had you gotten any results in terms of the ballistics, the firearms, the trajectory, the stippling, whatever evidence regarding that?
No, sir.
Had you spoken to a girl or lady that was speaking to the victim on the phone at the time or right before the time that this murder happened?
No, sir.
Had you analyzed the phone records and the conversations between the victim, Trayvon Martin, and this lady that he was speaking to? Her name's Rachel Gentile.
No, sir.
Had you seen the 7-Eleven video?
No, sir, I had not.
You also did, obviously, reports in this case, correct?
Yes, sir.
And in some of those reports, did you in some way write down some inconsistencies, what you felt were some inconsistencies based on the statements that the defendant had given you?
Concerns of mine about his statements, correct? Yes, sir.
Okay. You mentioned at some point or you were asked about the size of the individuals, correct? Mr. Martin and the defendant, correct?
The physical sizes?
Yeah, I'm sorry, the victim.
Yes.
And I think, did you describe, I apologize if I got it wrong, did you describe the victim as a skinny kid or something to that effect?
Yes, sir, I did.
Would you classify the defendant, when you came into contact, as a skinny kid?
Would I classify the defendant as skinny?
Yeah, as a skinny kid?
No, sir.
Would it be fair to say the bottom line, sir, is that after February 29th and after a later date, the investigation was turned over to somebody else, is that correct?
As of what date, sir?
After that interview, at a later date in March, the investigation was turned over to another agency?
Yes, sir.
So, Mr. O'Mara asked you about phone calls that you had, telephone conversations with the defendant. Do you recall that?
Yes, sir.
Okay. Was your intent to eventually, if you could, attempt to interview the defendant again and challenge him, I guess to use Mr. O'Mara's words?
Absolutely, yes, sir.
If I can have a moment, Your Honor.
Yes, you may.
I don't have any further questions.
Thank you. And you recross?